case is entitled State of Ohio, Arthur Pacas, case numbers 24 CR 001250 and 26 CR 000127. In the 2026 case, we are here on defendant is present open court today with his counsel Carlos Johnson. In the 127 case from 2026, we are here on the 3-count information that was filed on February 25th of 2026. Those 3 counts being failure to comply with an order or signal of a police officer, a felony of the 4th degree, obstructing official business, a felony of the 5th degree, and operating a vehicle under the influence of alcohol, a drug of abuse, or a combination of them, a misdemeanor of the 1st degree. It's the state's understanding in that case that the defendant will waive his right to indictment and will plead to the 3 counts in the information. State's understanding defense wishes to defer sentencing so that an updated pre-sentence report and drug and alcohol evaluation may be completed. The 2024 case is here on a motion to terminate community control sanctions filed on November 18th of 2025, as well as a supplement to that motion filed on January 12th of 2026. The state's understanding the defendant will waive his right to probable cause hearing, final hearing, and that both cases will then be set together for sentencing. And that's the state's understanding at this time.
Any discussions or agreements on as to recommendations for sentencing which form a part of the basis for the plea here?
No, I apologize. I did not mention that. There's no sentencing agreement.
Thank you. Mr. Johnson, does that all sound accurate?
May it please the court, Your Honor, that is a correct statement coming from the state of Ohio. I have explained to my client his trial as well as his constitutional rights, as well as his rights with respect for waiving grand jury presentment. I believe he will enter a guilty plea to the information as stated.
Thank you. Mr. Pacas, it's been represented here that it is your intention. Well, were you able to hear what they said here?
Yes, Your Honor.
It was represented that it's your desire to waive your right to have this particular case presented to a grand jury. This is the newer case, the new charges. And I'll explain what that means in more detail here in a second to make sure you understand that. You're then going to plead guilty to the 3 charges in this information. We would then defer sentencing to a future day to get an updated pre-sentence report, come back on a future day where there's no agreement between the parties regarding recommendations for sentencing. Each side is free to recommend to the court whatever sentence they think is the right thing to do. Is that your understanding, the discussions that took place between your lawyer and the prosecutor, most importantly, what you want to do today?
Yes, Your Honor.
Well, before I can accept your guilty plea, I need to make sure you understand everything going on here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine those issues, I'm going to ask you at this time a series of questions. Now, if at any point when I'm asking you any of these questions, if you're unsure or unclear of anything I'm asking you, if you need anything repeated and clarified, if you want a moment to talk with your lawyer so you could ask him questions, or even if you want to ask me questions, make sure you let me know that because I need to make sure you understand everything going on, all right?
Okay.
All right. Let's get started then. How old are you?
26.
Are you able to read and write the English language?
Yes, Your Honor.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No.
Are you a U.S. citizen?
Yes, Your Honor.
Now, before coming to court here this afternoon, have you any drugs or alcohol of any kind?
No, Your Honor.
What about in the last 48 hours?
No.
Not even prescribed medication, nothing?
No.
Did you receive a copy of the information that was filed in this case? That's the document that sets forth the specific charges that you're accused of committing and what you're pleading guilty to?
Yes, Your Honor.
And you had a chance to look those over?
Yes.
Now, in that information, you are charged with 3 counts. And count 1, what is alleged here and what you're admitting to, is on or about November 8th, 2025 in Painesville Township, Lake County, Ohio, that you did operate a motor vehicle so as willfully to elude or flee a police officer after you received a visible or audible signal from the police officer to bring your motor vehicle to a stop. Excuse me. That conduct constitutes the offense of failure to comply with an order or signal of a police officer. It's a felony of the 4th degree. Do you understand what you're charged with and pleading guilty to in this count?
Yes, Your Honor.
Any questions about it for me?
No.
Now, count 2 alleges on or about that same day, November 8th, 2025, in Painesville Township, Lake County, Ohio, that you did an act without privilege to do so, and with purpose to prevent, obstruct, or delay the performance by a public official of an authorized act within that public official's official capacity, that hampered or impeded the public official in the performance of the public official's lawful duties. It's further alleged the violation created a risk of physical harm to any person. That conduct with that finding constitutes the offense of obstructing official business. It's a felony of the 5th degree. Do you understand what you're charged with in pleading guilty to in count 2?
Yes, Your Honor.
Any questions about that?
No.
Lastly, in count 3, it's alleged on or about November 8th, 2025 in Painesville Township, Lake County, Ohio, that you did operate a vehicle under the influence of alcohol or drug abuse or a combination of them. That conduct constitutes the offense of operating a vehicle under the influence of alcohol, drug abuse, or a combination of them, and it's a misdemeanor of the 1st degree. It's further alleged that within 10 years of this offense, you have one prior conviction for operating a vehicle under the influence of alcohol or drug abuse. So do you understand what it is you're charged with and pleading guilty to in this information?
Yes, Your Honor.
Any questions for me about the charges?
No, Your Honor.
Well, then before I can accept your plea, I need to make sure you understand all the rights you are giving up. And you first of all have the right to have this case presented to a grand jury. So that document that I just read to you is called an information. And an information is criminal charges that are brought by the prosecuting attorney without this case having previously been considered by a grand jury. Now, what a grand jury is, it's made up of a group of citizens here from Lake County that get together and they meet privately. They meet in secret for the purpose of evaluating evidence in cases to determine whether probable cause exists that someone committed a crime. Probable cause is defined as some evidence that would suggest the person probably committed a criminal offense. Everyone here in Ohio accused of a felony has the right to have a grand jury independently review the evidence in a case and make a decision without the government at all being involved in that decision. And you have that right as well in regards to someone being charged with an offense. And you have that right as well. But you can give up that right if you desire and go forward on these charges brought by the prosecutor and the information, and your attorney has represented he believes that's what you want to do. Is that correct?
Yes, Your Honor.
Well, before I can go any further on this, I need to make sure you understand. I need to have you acknowledge here in open court in writing that you want to give up that right. And I have a one-page document called a waiver of indictment, which sets forth what I just explained to you about this grand jury process, and you want to give that up. Again, before I can go any further, I need to be this document. You sign it here in court. Now, my understanding is you had a chance to go over this with Mr. Johnson before I walked out here. Is that right?
Yes, Your Honor.
Mr. Johnson, is that accurate? Did you review this with your client, read it to him, explain it to him, answer his question? Did he indicate an understanding of it to you when you did that?
Yes, Your Honor.
Is that correct, Mr. Pacas?
Yes, Your Honor.
So you understand what this document says? It appears you signed it. Did you sign it?
Yes, Your
And
Honor.
Mr. Johnson, you witnessed that?
I did, Your
All
Honor.
right. And this cuts you as well?
Yes, Your Honor.
All right, so I'll make that document part of the record. At this point, I'm going to review with you all the other rights you have that you're giving up by pleading guilty, and you first of all have a right to a trial. Now, a trial could be to me as a judge, where I listen to all the evidence and I make that ultimate decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. A jury trial would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then those jurors would make that ultimate decision. And that ultimate decision reached by the 12 jurors would have to be a unanimous decision. Unanimous means all 12 of them would have to agree together, one way or the other, as to each charge, whether you're guilty or not guilty. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty, you're giving up your right to have a trial and a jury trial?
Yes, Your Honor.
Now, if we did have a trial, you'd have the right to have an attorney represent you at that trial. If you could not afford an attorney, the court would appoint one for you free of charge. Do you understand that?
Yes, Your Honor.
Now, at a trial, the prosecutor here would be representing the state of Ohio, and she would have what we call the burden of proof. Her having the burden of proof means that it's her job, or she bears the responsibility or the obligation of proving you guilty before you could ever be found guilty. You're presumed innocent of all these charges, and that presumption of innocence sticks with you and stays with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes, Your Honor.
Now, in an attempt to try to prove you guilty, if we did have a trial, the prosecutor would bring witnesses into the courtroom to testify for the state. They'd answer questions from the prosecutor. Once those witnesses answer the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions. That's called cross-examination. He could ask them anything he wanted to within certain rules. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty you're giving up your right to cross-examine or confront those witnesses that would come in here and testify against you?
Yes, Your Honor.
Now, you'd also have the right at a trial. You can call your own witnesses to come into court and testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that. But you have a right to do that if you wanted. Do you understand that?
Yes, Your Honor.
And you further can request the court issue an order. That order we call a subpoena. What a subpoena would actually do is force or make someone come into court and testify for you and answer your lawyer's questions if they were not willing to come in voluntarily on their own. Do you understand that?
Yes, Your Honor.
Do you realize you're giving up that right?
Yes.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify. That's a decision or a choice that you would have to make. Do you understand that?
Yes, Your Honor.
And since that's your choice, what that really means then is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But most importantly, the prosecutor here, she would not be allowed to call you as a witness and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes, Your Honor.
Further understand that if we went to trial of any of these charges, you would have the right to appeal or challenge that guilty finding to another court, a court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as raised or brought to my attention up to this time. Do you understand that?
Yes, Your Honor.
All right, well, do you have any questions at all about these rights we've just discussed? These are all the rights you have and all the rights you give up by pleading guilty. Any questions?
No, Your Honor.
Do you understand them all?
Yes, I do.
Do you still want?
Yes, sir.
Do you understand complete admission of guilt? It means you're admitting to the facts being alleged by the prosecutor. We're not going to argue later that you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes, Your Honor.
Further, as a result of pleading guilty, the effect of that plea is that you will be found guilty by the court, and then you will subsequently, on another day, be sentenced by the court. Do you understand that?
Yes, Your Honor.
Now, as far as potential sentencing goes, you're pleading guilty in count one. That's the failure to comply charge with a felony of the fourth degree. That is punishable by a possible term in prison of a minimum of 6 months, a maximum of 18 months, or any whole number in that range of 6 to 18. Do you understand that?
Yes, Your Honor.
Now, count two is the obstructing official business. That is a felony of the fifth degree, correct? It's
Correct.
felony of the fifth degree. I have it marked here different. A felony of the fifth degree is punishable by a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. Do you understand that?
Yes, Your Honor.
Last, at count three is the OVI. It's a misdemeanor of the first degree. It is punishable in this case due to the fact that it's your second one in 10 years. It's punishable by a possible term of local incarceration. Well, I say possible, mandatory term of at least 10 days, and you could be ordered to serve up to 6 months of local incarceration. When I say local incarceration, I mean the Lake County Jail, not prison, but Lake County Jail. So mandatory, a minimum of at least 10 days, up to possibly 6 months. You understand that?
Yes, Your Honor.
Now, there's 3 charges here. 2 of them are felonies. In regards to the felonies, if a prison term is imposed on, in this case, by law, any prison sentence imposed on the failure to comply with an order or signal of a police officer has to be served consecutive to any other prison sentence that is imposed. So if the prison term is imposed on counts 1 and 2, they would have to be served consecutive to each other. Consecutive means one after the other. You'd serve the prison term on count 1, finish that, then serve the prison term on count 2. Do you understand that?
Yes, Your Honor.
I have no authority to order that those prison terms be served concurrent, which means at the same time. They have to be served one after the other. Do you understand that?
Yes, Your Honor.
Now, in regards to count 3, the misdemeanor, if a prison sentence is imposed, any local incarceration ordered on the OVI charge in count 3 can't run consecutive. It has to be concurrent. So any sentence on a misdemeanor has to be concurrent to a prison term if a prison term is imposed for the felonies. Do you understand that?
Yes, Your Honor.
So in this case, you're looking at a maximum possible prison sentence of 30 months or 2.5 years in prison with all 3 charges. Do you understand that?
Yes, Your Honor.
Do you have any other charges pending against you anywhere else? New charges?
No, I don't.
I know you're on probation to me, obviously. Are you on probation anywhere else or supervision anyone else?
No, Your Honor.
All right. Well, in this case, there's obviously, as you're aware, we're going to address that here. There's a probation violation that was filed in part based on these new charges, and there's some other allegations as well. But if you commit a new crime while you are on probation, that is a probation violation that you can be charged with, and you have been in this case. I need to advise you that if a prison term is imposed in this case, it would have to be consecutive to any prison term that may get imposed on the other case if you're found to be in violation of your probation. You understand that? Because, again, the fleeing and eluding charge in this case, this new case, has to be consecutive to any other prison sentence imposed. You understand that?
Yes, Your Honor.
So if a prison term is imposed in this case, counts 1 and 2 would have to be consecutive. And if a prison term is imposed in the other case for violating your probation, that would have to be consecutive to that as well. You understand that?
Yes, Your Honor.
Now, if a prison term is imposed in this case upon your release from prison, you could be placed on what is called post-release control. It's sometimes referred to as parole. It's a period of supervision you would be on after you completed the prison sentence. And in this particular case, it could be up to 2 years. It's up for the parole authority to decide that. Do you understand that?
Yes, Your Honor.
And if you were put on post-release control and ever violated any of the conditions of your supervision, we would have a hearing to see if you're what's called a probation violator. If it was determined that you were... Oh, I'm talking about probation. I'm sorry. Thank you, Mary. Let me back up. If you were on post-release control and ever violated any of the conditions of your supervision, the parole authority back to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall 50% or half of whatever the prison term was imposed by the court. Do you understand that?
Yes, Your Honor.
All right. Now, aside from the possible prison terms I've just explained to you, there's other sanctions or penalties that could be ordered. You could be fined in this case. Well, you will be fined because the OVI requires a fine of at least $715 be imposed, and you could be fined up to $1,625 on count 3, the OVI charge. Do you understand that?
Yes, Your Honor.
Now, count 1, the fleeing and eluding charge, carries with it a possible fine of up to $5,000. And count 2, the obstructing official business, carries with it a possible fine of up to $2,500. So altogether, there's a maximum possible fine of $9,125, but at least a fine of $715 will be imposed for the OVI. You understand that?
Yes, Your Honor.
You could also be ordered to pay court costs or reimburse the county for any cost of confinement, community supervision, or treatment if any of that were applicable. Do you understand that?
Yes, Your Honor.
Also, in regards to the failure to comply charge in count 1, there's a mandatory license suspension of at least 3 years up to possibly a lifetime revocation of your license. Do you understand that?
Yes, Your Honor.
And for the OVI in count 3, there's a mandatory license suspension of at least 1 year up to possibly 7 years. Do you understand that?
Yes, Your Honor.
Now, a few moments ago, I explained the possible prison term you face. I used the word possible. Prison is not mandatory with these charges. You are eligible to be put on community control sanctions in this case, or what's another name we call probation. Do you understand that just because you're eligible doesn't mean you'll automatically be put on probation? It means I will consider that. I'll look at all the information that gets presented to the court, and I'll make the decision I think is the right thing to do. Do you understand that?
Yes, Your Honor.
If you are put on community control sanctions, it could be up to 5 years. As the judge, I have the discretion to order a wide variety of rules and conditions for you to follow. One of the conditions could be an order that you serve a term in the Lake County Jail of up to 6 months as a condition of your probation. You understand that?
Yes, Your Honor.
Further, if you are put on probation, you ever violate any of the rules or conditions of your probation, we'll have a hearing to see if you're a probation violator, and if it's determined that you were, I could extend your probation up to 5 years. I could impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I did that, I could be up to possible 30 months in prison. Counts 1 and 2 would have to be consecutive, and it would have to be consecutive to any other prison sentence that you may be serving at that time or that you're being sentenced to at that time. Do you understand that?
Yes, Your Honor.
Lastly, when we do proceed to the sentencing hearing on a future day, you're going to have the right at that time to say anything you want me to know or consider. Your lawyer can speak on your behalf. He can recommend the sentence to the court. The prosecutor can also recommend the sentence to the court. Do you understand that?
Yes, Your Honor.
Do you understand that whatever anyone says at sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation, and I don't have to follow that if I didn't think that was the right thing to do. Do you understand that?
Yes, Your Honor.
All right, well, do you have any questions at all about the potential penalties you face and what can happen at sentencing?
No, Your Honor.
You understand all the possible consequences?
Yes, I do, Your
Do
Honor.
you still want to plead guilty?
Yes, I do.
Have you had enough time to talk about this case with your lawyer and have him go over the report with you, discuss issues, answer whatever questions you may have?
Yes, I did.
Are you satisfied with the advice and counsel of your lawyer?
Yes.
Has he or anyone else made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty here?
No.
Have you been threatened or coerced in any way to plead guilty?
No.
Are you entering the plea freely and voluntarily?
Freely and voluntarily.
You're not being threatened in any way or forced to do this, right?
No.
All right, well, do you have any questions for me at this time regarding anything we've talked about, the rights you're giving up, penalties you face, what you're pleading guilty to? Any questions at all?
No, Your Honor.
Do you need any more time to talk to your lawyer before we go forward with your actual plea?
No, Your Honor.
All right, then what's going to happen at this point, the prosecutor here is going to explain for me what she believes the evidence would show if we had a trial. I want you to listen to her, because then I'm going to have some follow-up questions for you, all right?
Okay, thank you.
Ms. Cutts?
Thank you, Your Honor. Had this matter proceeded to trial, the state would have proven beyond a reasonable doubt that on November 8th of 2025, shortly after 2:30 in the morning, Ohio State Highway Patrol Sergeant Pickett was traveling eastbound on State Route 2 in Lake County, Ohio. There was a vehicle in front of him. They were going into a construction area zone. There were barrels set up. There were signs stating that the exit ramp was closed. However, the vehicle in front of the cruiser drove between the cones to exit where there were active workers painting the lines. Officer activated his overhead lights to try and stop the vehicle. Defendant did initially pull over. The vehicle pulled over. The driver and only occupant was the defendant, Arthur Pacas. He indicated that he did see the signs and the workers waving their hands. He thought he could go. Officer noted his pupils were dilated and a strong odor of an alcoholic beverage was coming from the vehicle. Defendant indicated that he did not have anything to drink. He did get out of the car and perform standard field sobriety tests, including the HGN, which he had 6 out of 6 clues with no vertical nystagmus. He had issues with the walk and turn. He did successfully do the one-leg stand. He did have issues with the alphabet, both starting in the middle as well as just doing the full alphabet. He agreed to do a portable breath test, but did not fully blow into it. It did have a reading, however, it was not a full reading, but it was .072. Officer went to arrest the defendant, where he began to pull away from the sergeant. He was told that he was being placed under arrest for drinking and driving. He pulled fully away from the sergeant and ran to his car. He was tased by the sergeant, however, he was able to stand up and get into his vehicle. The sergeant was attempting not to have him get in the vehicle and had to jump back to avoid being dragged or run over when the defendant took off in the vehicle at a high rate of speed. The defendant was going in the direction of his residence. The officer got back into his car with sirens going and followed the defendant, who went through stop signs and was going through a high rate of speed. There was at least one vehicle on the street before the sergeant lost sight of the vehicle. He continued to 700 North Creek Drive, which is the area where the defendant lives, knocked on the address and the door at that address. Nobody answered. At that point, the defendant was not located that evening, but he had left his driver's license with the officer, and they were able to locate him at a later date. All of this occurring in Lake County, Ohio, and that would have been the state's evidence.
Thank you. Mr. Pacas, were you able to hear what the prosecutor just had to say regarding what she believes the evidence would show if we had a trial?
Yes, Your Honor.
What, if anything, did it say about those facts as she presented them? Are they accurate? Did you do what she said?
Yes, Your Honor.
Very well. Regarding count 1, charging with failure to comply with an order or signal of a police officer, a felony of the 4th degree, what is your plea to that count?
Could you repeat it?
Regarding count 1, where you're charged with failure to comply with an order or signal of a police officer, it's a felony of the 4th degree, what is your plea at this time?
Plead guilty.
Regarding count 2, charging with obstructing official business, a felony of the 5th degree, what is your plea to that count?
Plead guilty.
Regarding count 3, charging with operating a vehicle under the influence of alcohol, a drug of abuse, or a combination of them, a misdemeanor of the 1st degree, what is your plea to that?
Plead guilty.
All right, I have in my possession up here as well a 4-page document that's called a written plea of guilty and judgment entry, which sets forth everything I've just explained to you. Before I can accept your plea, I need to make sure you understand this document and that you sign it here in open court. My understanding is, in regards to this document, that, again, you also had a chance to go over that with Mr. Johnson before I came out here. Is that correct?
Yes, Your Honor.
Mr. Johnson, again, is that accurate? Did you review that with him, read it over with him, answer his questions?
Yes, Your Honor.
And did he indicate an understanding of that document to you?
Yes, Your Honor.
Is that correct, Mr. Pacas?
Yes, Your Honor.
You understand what the document says?
Yes, Your Honor.
Any questions from me?
No, Your Honor.
It also appears you signed this document too, is that correct?
Yes.
And Mr. Johnson, you witnessed that?
Yes, Your Honor.
And you too, Ms. Cutts?
Yes, Your Honor.
Very well, then, at this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect. The defendant was here in open court with his lawyer, advised of all his constitutional rights, and made a knowing, intelligent, and voluntary waiver of those rights. Court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding all this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea. Find the defendant guilty of count 1, failure to comply with an order or signal of a police officer, a felony of the 4th degree in violation of 2921.331B. Count 2, obstructing official business, a felony of the 5th degree, that is in violation of 2921.31 of the revised code. And then lastly, count 3, operating a vehicle under the influence of alcohol, a drug of abuse, or a combination of them, a misdemeanor of the 1st degree, violation of 4511.19A1A. I will defer sentencing. I'm going to order an updated pre-sentence report. You wanted a drug and alcohol evaluation as well, Mr. Johnson?
Yes, Your Honor.
We'll do that. Bond is, $10,000 cash surety. Is that correct, Ms. Cutts?
Your Honor, because there were 2 cases consolidated, it's $20,000 cash surety or 10%.
Okay. All right, bond will be continued at $20,000 cash surety, 10%. So, let's proceed to the other case at this time. In that case, the record, it's 24 CR 1250. In that case, a motion to terminate community control sanctions was previously filed, as well as an addendum to that motion being filed. Mr. Johnson, what is the defendant's intentions at this time regarding any hearings on the motion to terminate community control?
Your Honor, at this juncture, we would waive any preliminary hearing or probable cause hearing. We would like to continue it for sentencing with respect to the case we're here on.
So you have the probable cause hearing. There's also a final hearing in the merits. Do you want to waive that?
We would waive that as well.
So is it his intention then to admit to the violations at
That
this
is
point and
correct.
then continue the sentence? You'd like to continue the sentencing though?
Correct.
Okay. Well, Mr. Pacas, you have been charged with violating the conditions of your community control sanctions, specifically as alleged several violations here. The first is a Rule 2 violation, which requires you to report to your probation officer immediately any contact you may have with law enforcement or any citations you received or arrests. It's alleged that you did not report your contact with the Ohio State Highway Patrol that occurred on November 8th, 2025. It's further alleged a violation of Rule 1, which requires you to obey all local, state, and federal laws. On November 13th, you were charged with operating a vehicle under the influence of alcohol and driving on a closed road in the Painesville Municipal Court. An addendum was then filed regarding your probation, alleging five additional violations. First two are additional Rule 1 violations. Again, Rule 1 requires you to obey all local, state, and federal laws, and it's alleged on November 13th you were charged with fleeing and eluding, or failure to comply with an order of single police officer, obstructing official business, which are the charges that you just pled guilty to. It's also alleged that you were I'm going to dismiss the second Rule 1 violation. That deals with being charged with resisting arrest, but he didn't plead to that, so I'll dismiss that violation. The next one is a Rule 8 violation. Rule 8 prohibits you from using, possessing, or having under your control any controlled substance not prescribed to you by a licensed physician, and alcohol is also prohibited. And it's alleged that on November 13th that you had a strong odor of alcoholic beverage on you and then emitted from your breath during that traffic stop. The next allegation is a Rule 9 violation. Rule 9 requires you, or prohibits you, I should say, from leaving Lake County or your county of residence without any permission from your probation officer, and you're not to leave the state of Ohio without permission from the court. And it's alleged that you left the state of Ohio without permission. You were ultimately apprehended in Miami, Florida on November 30th, 2025. Lastly, it's alleged you violated Rule 3. Rule 3 requires you to report at such times and places as directed by your probation officer. It's alleged you failed to report for your scheduled appointment on November 26, 2025 and thereafter. Now, you have the right to have a couple of hearings regarding these allegations. The first is a hearing called a probable cause hearing, where the state is required to present some evidence that would suggest you probably committed these violations. You also have the right to have a final hearing on the merits, and that would be on another day and time if you wanted, so you could have time to prepare for that with your lawyer. And that's a hearing where the state would prove or have to prove the actual merits of what they're alleging. Now, you could have either or both of these hearings, but you could also waive the hearings if you desire and plead guilty to the violations. Your attorney has indicated he believes that's what you want to do, is waive both of the hearings and plead guilty. Is that correct?
Yes, Your Honor.
Well, before I can accept your waiver and your admission, I need to make sure you understand what the potential consequences could be if you are found to have violated your community control sanctions. If, in fact, that did occur, the court could extend your probation up to 5 years. I could order more restrictive sanctions against you, or I could terminate or end your probation at that point and send you to prison. If I did that, in this particular case, it could be anywhere from 6 to 18 months in prison. And that can also be served, would have to be served consecutive to any other prison sentence that could get imposed in another case. For the example, the other case that we have, that would have to be consecutive because the other case has a fleeing and eluding charge. And it could be consecutive to any other charges if something else should come up or being sentenced to at that time. You understand that?
Yes, Your Honor.
Well, having been advised the potential penalties you face, what would you like to do at this time? Do you want to have either of the hearings, or do you want to waive both hearings and plead guilty to the violations?
Waive and plead guilty.
Very well then. As to the allegation that you violated Rule 2 by not reporting contact with the Ohio State Highway Patrol on November 8th, what is your plea to that?
Yes, Your Honor.
I'm sorry?
Pardon me?
What is your plea to failing to report contact with the Ohio State Highway Patrol on November 8th?
Plead guilty.
Megan, what is that incident? I know we talked about this before in the past, but I can't recall. That's different from what the November 13th incident.
Our case that he just pled to in the info is November 8th. I think the November 13th is that's when he was officially charged in the court and there was an error, but the incident happened on November 8th.
Okay. That's right, that's what I said when I read this. Okay, so there's only one contact with the police.
That is my understanding, correct.
All right, in regards to Rule 1, for having been arrested for and ultimately convicted now of operating a vehicle under the influence of alcohol, what is your plea to that?
Plead guilty.
In regards to the other Rule 1 violation for having been convicted of failure to comply with an order of signal of a police officer and obstructing official business, both felonies, what is your plea to that?
Plead guilty, Your Honor.
As to the Rule 8 violation for drinking alcohol on November 13th, what is your plea to that?
Plead guilty.
As to the Rule 9 violation for leaving the state of Ohio without permission, what is your plea to that?
Plead guilty.
And lastly, as the Rule 3 violation for failing to report to your probation officer since November 26th of last year, what is your plea to that?
Plead guilty, Your Honor.
All right, the court will accept your pleas of guilty, find that you did violate your community control sanctions. I will defer sentencing as you request, Mr. Johnson, and we'll conduct the sentencing hearing on these probation violations at the same time that we conduct the sentencing hearing for the new case that he just pled guilty to.
Okay.
So I think that covers everything. Mr. Johnson, anything else you care to address at this point?
Your Honor, may it please the court, he has yet to make the $20,000 bond in the matter, but I've also asked that there's a holder with respect to the probation case. If we could lift the holder, give him a GPS monitor, and let him kind of get his affairs together. He has a house in the community. Speaking with his family, still has a possibility of keeping his job. He's taken the matter very seriously. He's hired counsel, GPS monitor would track his whereabouts. You could also put a scram on him if you like, so we know he wouldn't consume any alcohol, and just give him time to come back on the sentencing date.
Well, the court's not going to set a bond in the probation violation case. He left the state. He hasn't reported. I don't set bonds on probation violations anyway. It's nothing unique to Mr. Pacas, but there's nothing that's been presented that would make me override what I normally do. So I'm not setting a bond in that case.
Thank you, Your Honor.
Ms. Cutts, anything else?
No, thank you.